Hello, everybody. Welcome back to Radio Entrepreneurs. And boy, the stories have been flying. The economy has been just in total chaos. We don't know from day to day what's going on. And we keep talking to entrepreneurs and experts about how people are dealing with this economy. And so critical to our show is our weekly segment with Mark Furman from Tarlow, Hart, and Rodgers, in which he discusses entrepreneurship and the law. Welcome back, Mark.
Hey, Jeffrey. How are you?
Good,
Great to be with you.
Great to be with you, Mark. Love seeing you. Mark, I don't even know if you can figure out always what to talk about from week to week or day to day.
Well, there's always something in the news, and but what I wanted to talk today about is the First Amendment, which guarantees freedom of speech, freedom of religion, gives the right to petition the government. And an issue that's out there is if you complain to the government about something, should you be able to be sued for it? If a business person has an issue with a competitor, can they petition the government about it, or and can that competitor sue them? And if so, can they sue them for? So I start with the premise, everybody's got a right to petition the government, but you have this question: what if their petition is in bad faith? What if there's an ulterior purpose behind it? What if it's what they're claiming in the petition is false? Where's the line between the constitutional protection for petitioning the government and protecting the rights of the party who is being accused? So I would say the law is, as in many cases, inconsistent and in a state of constant flux and evolution. But one of the developments over the last few decades is there was an antitrust case that went to the Supreme Court, and the Supreme Court decided that parties cannot be liable for petitioning the government except in very limited circumstances. So in order to be liable, your petition to the government must be what's called a sham. And a sham is litigation, say, or activity which is objectively baseless. So if it's not objectively baseless, you're done. You're protected. You're immunized. You don't go to the question of what is the intent behind the petitioning activity. So, so should that be the rule? That should be throughout the law, that if you have a claim, a petition that is not objectively baseless, should you have immunity? In other words, if there's a good faith basis for the claim, even if your intent is malevolent, should it matter? And in that particular case, in the antitrust context, the United States Supreme Court held that intent is irrelevant as long as it's not objectively baseless. So it's a nice bright line standard. Judges can look at whether a claim on the merits has a legitimate basis or not, or whether it's just nonsense and baseless. And you don't get into what's in the hearts and minds of of the party petitioning the government. So courts have taken that antitrust case and applied it all sorts of petitioning activity. And it's being decided from state to state, and it's being decided in different ways. So some states say, well, that's just an antitrust case. And other states say, well, there's no difference between petitioning the government in an antitrust context as opposed to petitioning the government in some other context. And people, including business people, businesses and business owners, have the same right to petition as individual parties. So what do you think, Jeff? Wonder what listeners think. Should you get, if you have a legitimate basis, looking at it just objectively, should there be circumstances that you're liable for petitioning activity or not?
Well, the whole thing around good faith makes me think about proving it and what the cost is of proving it. Again, I've had this discussion with other people, and just, when you're a small business, as you know, the cost of litigation or even the pursuit of inquiry can be an immense distraction to a small business. And, I don't think it's ever a flat an equal playing field, because big businesses can last a lot longer. And, that's a problem. I mean, I know somebody who used to tell me a story about an ex-president who he did business with. And he used to say there were two types of deals with that president. One where you made a contract and he broke it. And then two, when you didn't make a contract and he broke it. And he said, and when he broke it, he used to say, we'll go to court and I'll just outlast you. So it's tough, and I've mentioned this before. In some countries, there's sort of recourse around these big companies being able to take advantage in lawsuits. So that's really my concern, Mark. It's really, how many avenues do small businesses have? And I see a lot of inappropriate behavior in business. It happens all the time. So that's my question back. It's, are there easier routes for small businesses?
Yeah. Well, that's the problem. I mean, people, when they got a complaint, they think they can go to the government and they don't expect to be sued. But if you're talking about small businesses, I mean, one of the major inconveniences is the expense is enormous of defending. I mean, I think that's what you're alluding to. And the playing field is never level, in the sense that, unless the Amazon was fighting with Apple, or you're talking about mega companies like that, for the average entrepreneur, defending a case really can pose an existential threat to the business. So the advantage of an objective standard, where if it's objectively not frivolous, is that it's an opportunity to discourage suits against smaller parties and potentially provide, through the legal process, expedited consideration that may dispose of the case without waiting for trial and going through all the expense of discovery. Now, the counter argument is that when that business or business owner or both get sued, if they can't be sued, are you depriving the party that sues them of their right to petition the government? Because they have a First Amendment right as well. So how do you balance these rights to petition? And I think that's what the courts are grappling with. And
I'm glad they are. I'm glad they are. And I think it's hard for attorneys too. I mean, you've got to pick an attorney that you can afford, and you want to make sure that you can pay your attorney, and attorneys can't take cases where they can't get paid. It's a tough bind all the way around. I think it's a great subject, and hopefully you can bring it up again. We are speaking with Mark Furman, Tarlow, Hart, and Rodgers. Entrepreneurship and the Law is this segment. Mark, if someone's looking for you and want to understand how to navigate these very difficult situations, how would they find you?
I can be reached at 617-218-2025. That's my direct line. Or at mfurman, Furman, at tbhr-law.com.
That's great. And remind everybody, this is Radio Entrepreneurs, and we'll see Mark next week. Back again.